Hello and welcome to the Paducah Human Rights Commission Raising the Standard. My name is Gary Reese. I'm your host today. I'm the chair of the Paducah Human Rights Commission. We have two great guests with us today, Sam Bussey and Sam Clymer. Sam Bussey is with Mark Bryant. She's an attorney with Mark Bryant's office. And of course, Sam Clymer is our county attorney, so we're glad to have you all with us today. Today's topic will be sex discrimination, and we'll also get into sexual harassment to some degree. So let's start, if you don't mind, we'll start with kind of the general topic of discrimination, and we'll kind of define that, if you don't mind. What basically, just in a real simple nutshell, would discrimination, in what areas, maybe like occupational areas, are we oftentimes concerned with discrimination?
Now the challenge is going to be you got two lawyers sitting there.
That's right.
So we're going to have to come up with some kind of code or some sort of inclination as to who's going to go. You want to go first? You want me to go?
Sure, and then we can kind of bounce off of each other. So I would say that discrimination is an overall concept of it would be showing favoritism or a preference for a particular group of individuals, whether it be on their sex, religious beliefs, national origin. And that's basically like the overarching definition of discrimination. I would say some occupations where it's predominantly found would be, I guess, what stereotype of a gender role, like say for instance a nurse, you know, maybe even a teaching profession, depending on what type of area for teaching it is. I don't know, do you have any other ones?
Well, one of the things from a governmental standpoint, as county attorney, one of the things that I'm required to do is to advise all the county boards, commissions, officers, offices, and the fiscal court as well as to how to avoid potential discriminatory actions. One thing that we don't see quite so much anymore that was pervasive in law enforcement back in the olden days, and you may have even seen something like this happen back when you were active. There used to be height, weight requirements. Yes. There used to be a requirement that an individual be able to lift a certain amount of weight that was not really indicative or necessary to carrying out the job functions as a way to essentially eliminate females.
Right.
And really we have come so far at this point in getting past that. I'm sure that others may have some anecdotal tales where they may have seen discrimination in place, but I'll share with you that one thing really neat that I learned recently is not only do we have, I think, possibly 4 to 6 active female Paducah police officers, and we have 3, I believe, deputy sheriffs that are females, but we have our first SWAT member that is a female. And so that's really the one that really jumped out at me was law enforcement and the requirements to be eligible. And we've moved past that, and we now have actual special weapons and tactics folks that are female.
Right.
To bounce off that, I recently toured the barges here, and I'm in Leadership Paducah, and they were talking about a deckhand position, and typically that's a male, you know, dominant position, and a female they had recently hired. A lot of the men were worried that she wouldn't be able to handle the weight and some of the duties that they have, and she ended up being the best employee they had, and just, you know, outdid all the males. So it is really kind of, you know, cool to see that happening, transition in that role.
There's a term, this kind of gets into this term, a bona fide occupational qualification, Bfoq, that you all probably heard about. And in the selection process, obviously there can't, the job requirements and any tests that are used, they have to be based on actual job qualifications. Can you explain a little bit more about what that is? And
do you want to hit on that, Sam? Because I don't.
Sure.
Going beyond the law enforcement aspect of it, given my limited role, and I'm not a civil practitioner anymore. I'm more of dealing with the governmental type actions. I see that a little bit every now and then with road department employees. You know, they're required to be able to lift a certain amount of weight because it's obvious that
it has to be a job requirement.
Right, exactly. There's no more height weight requirements, anything of that nature, but there is generalized health requirements. There is the ability to be on one's feet for a certain amount of time. You have to pass a physical. and the physical is uniformly applied to all applicants.
Okay.
That's really as far as what I see. And
Right,
I'd
right.
defer to Sam for any other examples if you know of any.
Sure. So typically that relates to, like, say if a certain job requires a certain sex to be performed or like a certain religion. So like say, you know, somebody is applying to be, you know, a priest of a Catholic church or getting, obviously they would have to be Catholic. Those are the type of things
Right,
that, you know, would be one of those qualifications. Or another one would be like an acting position. If it was, you know, they were trying to hire for a female role.
Right, right.
Obviously, they would want a female to play that role.
Absolutely.
So those kind of things fall into that qualification.
Okay, okay. Let's go back to the law for just a moment, if you don't mind, and explain to us, I know there's some protected classes in the Civil Rights Act and I guess some of the other sex discrimination-based laws. Can you explain what some of those are and maybe how they came about to be what we would call protected classes?
Kind of like the bar exam all over again.
It is.
Yeah, so I mean, you have your basics, you know, like race, sex,
Right.
national origin,
Right.
religion, and, you know, those are pretty much a vague description, but those are usually the classes that are. I'm probably missing some, but as far as,
Well,
I think that covers,
that pretty well covers the most prevalent
Yeah.
victims of discrimination
right,
that we see.
disability,
Yeah,
obviously.
disability.
Okay.
And a lot of that stems from, like for instance, when we're talking about the protected classes, from a harassment standpoint, there's a little bit of a differentiation when you see discrimination in the workplace versus discrimination outside of the workplace. And this I'm trying to stay on
No, that's okay.
in response to your question,
right.
but it's one of the things that I learned about discrimination that I found to be very interesting, is that Title VII of the Civil Rights Act of 1964 gives protected classes a legitimate statutory expectation to be treated equally to other similarly situated individuals. That's the
Right.
whole point.
Right.
That's what it is. Kentucky has passed, it's a KRS, the chapter is 344, but it essentially mirrors the Civil Rights Act of 64.
Right.
That, so we have federal protections and we have state protections. And those two protections are offered for discrimination in the workplace.
Right. Okay.
I think the Title VII applies when you have 15 or greater employees, and 344 applies if you have 8 and greater employees. But what a lot of times folks overlook is that there are protections against discrimination via the 14th Amendment. And that essentially says that you know, everybody gets equal protection of the law, which has
Right.
been interpreted to mean that similarly situated individuals must be treated in a similar fashion.
Right.
It applies to governmental and quasi-governmental actors, but it's free of, it's not bound to the workplace.
Right.
It can be in any type of governmental type of action geared toward a person that treats them dissimilarly to another person that they're equally situated with.
Okay.
And you can actually sue the government for doing that under, it's what we've all heard being governmental actors, 42 USCA 1983.
Yeah.
That's right.
I've heard of that too.
Yeah, that comes up every now and then.
Right.
But
right.
yeah, that's the way by which folks that are aggrieved under truly any deprivation of a civil right or any right whatsoever, statutory, constitutional, whatever, they can sue for redress of their grievances that way.
Is it true that, and I think this is something I've learned in my American government class, is it true that over time, right off the bat, maybe there were some protected classes that we have now that are protected that were not originally included in that? Is this something that we've kind of, in this country, we've kind of gradually added to over time since 1964?
Oh, I think so.
Yeah.
I mean, particularly in the last maybe 20 years or so.
Yeah, I think some of the terms have also been broadened a little bit, like say for, you know, gender, just an example, like transgender now falls under that. And I think we're moving towards, you know, including sexual orientation. Some states have included it, you know, and
My
hopefully we're
research showed that
progressive.
it actually is federally protected now, sexual orientation. You've got national origin, race, religion, sex, sexual orientation, whether or not you would be qualified or classified as a handicapped individual. And I think I think the protection is in place for transgender individuals as well.
At the federal level?
At the federal level,
Okay,
yeah.
okay.
I can't speak to where Kentucky is on that. I stopped my research at in the federal statutes.
Right. Well, how prevalent is sex discrimination, do you think? And if somebody believes they're a victim, what recourse do they have?
You want to start on that, or you want me to go?
You go ahead.
Okay. Okay. Well, in my particular line of work, I can tell you what my experience shows. And I am, since I'm not a civil practitioner anymore, I don't handle civil rights lawsuits prosecuting individuals for discrimination anymore. What I do is, as I alluded to before, is I try to educate, I try to prevent discrimination through education of my people, which are the county offices, the county officers, all boards, special districts, anything that says McCracken County in it, I'm responsible for making sure they don't discriminate.
Right.
And so what I did is when I first got into the office, I did an extensive research project that I should have brought here today to share a copy with you guys, but it's essentially entitled Discrimination under Kentucky and Federal Law and How to Avoid Liability. And essentially, and I'm not saying how to get out of trouble, how to avoid liability, it's how to not put yourself into the position where a liability could be alleged. So what I do is I try to educate the county actors as to what's not acceptable. And I try to educate them as to what corrective action, remedial action they take as soon as there is an allegation of some kind of wrongdoing. And I've actually had to be party to a meeting, well, 2 different meetings, where there was some pretty obvious sexual motivated, not sexual, but gender motivated discrimination going on. And I'm not going to get into any specifics with it, but my course of action when that happens is that's a federally protected right. It's obvious that something like that has been going on. It's been previously reported to supervisors, and the supervisors then brought it to me because it exposed the county to liability. So what I did is I pulled in the district, or the judge executive, the deputy judge executive, and the person accused, and told them, here's the evidence that we've compiled. Here's what we think is going on. If it happens again, you'll be summarily terminated. It's an at-will state. That individual will be terminated immediately upon the next allegation.
Right. And there's certain, and I want to get off into, in just a minute, sexual harassment. That's kind of where we're going now. But there's some liability for supervisors if they know that there's some sex-based discrimination going on. They have to, they're required, I'm assuming by law, to take some sort of action to make sure that it's resolved. Is that true?
Yes, that's definitely right. There's a little bit of tort law, a little bit of gymnastics that goes into this. Like if an individual is, we have our 2 different types of sexual harassment. We have the quid pro quo sexual harassment, which is you're going to get extra money if you have sex with me, or you're going to get fired if you don't. Something like that.
Exchange.
Yeah, exchanges. And then you have hostile work environment. I don't think it takes a special kind of person to engage in quid pro quo sexual harassment. So what we see, not regularly, but what we're most likely to see is a hostile work environment, which means that there is either a pervasive or a severe atmosphere or activity related to harassment of an individual based on their being a protected class member, their sex. What happens is if it's a supervisor essentially is seen as an authorized agent of the employer, and liability will be imputed to the employer via the supervisor either acting in such a way or allowing non-supervisory employees to act in such a way. If it's a non-supervisory employee and the supervisor doesn't take action, then liability can be imputed back to the supervisor and the organization under a theory called vicarious liability.
If you don't mind, I want to get into what specifically would be, I know you named the 2 types of sexual harassment, the quid pro quo and the hostile environment thing. What's the differences between sexual harassment, I guess, and sex-based discrimination in terms of, say, workplace practices and things like that? Can you Can you give us a little bit of an example? Or,
You want to take a run at that one?
Sure. I feel like with sex-based, like workplace discrimination, that's more on the line, along the lines of the type of like work that's involved, or the
Right.
pay,
Okay.
something like that. Not paying a female as much as a male, or not allowing a female to move up in the position because a male is more qualified,
right.
so to speak. Whereas I think like the quid pro quo is more so, well, you're not going to get a raise if you don't do this type of sexual act for me, or maybe it doesn't even have to be necessarily a sexual favor. It can be a term, using a term that is offensive to a female, calling a
Right.
female a derogatory name, calling a male a derogatory name. And I think that's kind of a misconception, is everybody thinks sexual harassment obviously has to do with some type of sexual act,
Right.
which is not always the case. So I think that's kind of the difference between the two.
Okay.
And along those lines, here's something that I learned recently that I thought was a really nice extrapolation, as far as, or it'll kind of illustrate for us how far sexual harassment reaches. And it's not necessarily, and this was news to me, that I learned this at a conference. It's not that it has to be based upon sexual acts, sexual advances, or using sexual inappropriate language, something like that. It can actually be, liability can be imputed if, like, say you got a bunch of guys in the office and you got a new girl that works there, and maybe somebody killed a frog, or somebody went fishing, got a fish, put it on her desk or put it on her
Right.
car, and they're like, hey, this will gross her out because she's a girl. It has nothing to do with
Right,
sex,
right.
but they do it because she's a member of a protected class, being a
Right.
female, and they wouldn't do that to the boys.
Right.
So,
Yeah.
so that's an interesting way to show you just how far-reaching it
is.
can go.
I think that's a good example of exactly how far it is, and it's things that I wouldn't have even thought about.
Yeah.
But I can see what you're
Right.
talking about. So
That was like, somebody actually had to do that for it to be a test case
Yeah.
and be ruled on by the court.
Yeah.
Yeah.
well, you mentioned something about equal pay. Can you talk a little bit about the Equal Pay Act? Is that
Yeah,
Okay.
so that's obviously covered under the EEOC,
Okay.
the Civil Rights Act that Sam mentioned earlier, Title VII.
okay?
So basically, a male or female can't get paid more than the other for doing the same job that they are qualified for, both qualified for. And I think that's been a big thing that's been going on right now as a current situation, men getting paid more than women, and I still think there's a little fight between that, but that's essentially what the Equal Pay Act was invented for, or created for.
Okay.
So,
And you mentioned the EEOC. Can you explain a little bit about what explain what it is and what its
Yeah.
function is, so to speak?
so it's the Equal Employment Opportunity Commission.
Okay.
And basically, its function is to protect. It's on a federal level. It's to protect, individuals who have been discriminated against sexually, or on their race, national origin, those type of things. And they do have a website you can go to, eeoc.gov. And I think if you even put like /laws, it'll come up everything. And it shows the different laws that are under it. The Civil Rights Act, like I said, the Equal Pay Act. There's even the Pregnancy Act that was created under it. And you can even file charges through the EEOC's website. And they also have statistics broken down by your state. You can search your state, how many charges have been filed, and then how many that is in the United States, where your state fits. And I actually found out that Kentucky has, we had, in 2016, that's the most current year that they have, the most recent year, and it was 30% of charges have been filed based on sex discrimination, which is equivalent to like 1% out of the U.S. So I thought that was
So
kinda
we rank
interesting.
pretty high
Well,
on the list.
I mean, I guess it kind of would be like from the years that they had from 2009, and we were higher, and then it kind of dropped off,
Okay.
and then we got higher again, and now it's actually down. I think we're down 4% from last year, so that's a good thing.
Right.
Obviously, we'd like it lower, but
The kind of high ranking we're after.
yeah, definitely not.
Yeah.
If a small business, say, or an employer or somebody has questions about, let's say, for example, what types of questions they should ask of a potential candidate or during a job interview, is there a place that they can go to? I know for the county, obviously it would be you, but just to say some private business, is there somewhere they can go if they have questions about what they should and should not do in terms of hiring people?
I would say definitely to, talk to your local Human Rights Commission, to figure out if there are some things that you should avoid. I think a lot of employers kind of know some areas to avoid, but just to make sure, for purposes of liability, use your local resources for sure. That's what, the Human Rights Commission was set up to help and advise. And then, of course, our lovely county attorney over here.
Oh, sure.
You would help anybody, right? No
Oh, anybody.
Government or not, okay.
Oh, doesn't matter.
All right. What about retaliation? What steps, if a person feels like they've made a complaint and they feel like they're being retaliated against, what steps can they take, and what's the recourse for them?
Would that be like I've dealt with that in a whistleblower type of situation.
Right.
And I've dealt with it also in you don't really see it quite so much in the sex discrimination, at least I don't. It usually seems to be just outright sex discrimination, and I guess maybe you could see retaliation if you voiced your concerns to a supervisory authority and they pretty much just like moved you to a bad shift or something like that. I have seen something like that happen that was immediately resolved.
Right.
But somebody that was enjoying day shift got moved to midnights, and it was under the I hate to say under the guise of, it was individual's kind of a problem employee to begin with. Then this employee came forward with some allegations of harassment. I don't believe it was even sexual in nature. But in order to remove them from that situation, they were brought from day shift to midnight shift. The problem is they got 3 kids.
Right.
And it was almost more of a, hey, I'm going to wink, wink, nod, nod, protect you, but I'm also going to make sure you keep your mouth shut.
Yeah.
That was remedied swiftly by the individual who made the decision.
Right.
That's about all I can probably say about that.
All right.
Oh, one thing, Gary, I'm sorry, you asked me before about an individual's remedies if they were to be sexually discriminated against, and we talked about the EEOC a little bit, but I think it's definitely worth mentioning that one of the actual conditions precedent or requirement to be able to bring suit under Title VII is that you have to do what's called exhaustion of your administrative remedies.
Okay.
And that means that the EEOC is an administrative body. You have to first begin with the EEOC. You have to file your complaint. The complaint is received, and the respondent, the employer, gets an opportunity to respond in writing. Then an investigation is launched. And based on the findings of the investigation, the EEOC will either make a finding of yes, there was discrimination, or no, there was not. If they find that no, there was not discrimination that we can substantiate or find probable cause to support, then they'll issue the individual what's called a letter of a right to sue letter. That means you've administratively exhausted your remedies and you can now sue in court. If the EEOC finds that there was discrimination, then they have the opportunity actually through their staff to file a lawsuit on the behalf of the complaining person. If they elect not to do that for whatever reason, then they'll give you a right to sue letter.
Right.
And that's actually a prerequisite to being able to sue and assert your federal rights.
Okay. Okay.
I feel like that's worth mentioning.
Yeah,
that's a lot of
absolutely.
hoops to
Right.
go through.
Right, right. We've got about 4 or 5 minutes left. I want to ask a question that I know you're going to know about. It's about the law in regards to sex offenses and underage people having sex with people in authority. Can you explain what the law is on that?
Yeah, that's something that actually was modified, I think, in 2009. Is that right?
I do believe that is correct.
Okay.
Yes.
Okay. And I actually, in district court at that time, I was the criminal court prosecutor, and I had to handle a case that was a really good test case on that. What it is essentially it makes it a felony-related sexual offense for an individual to engage in sexual contact being a defined term. I mean, we're talking
Right.
about just touching another individual for sexual gratification. Doesn't even have to be intercourse.
Right.
But regardless of what the contact is or the intercourse may be, if it's a person that seemed to be in what's called a position of authority, and this is all kinds of stuff, that's another defined term, then that elevates or aggravates the level of the offense. And it could take an action which would not be an offense otherwise, but due to the nature of the relationship, it becomes an offense.
Right.
Prime example would be a youth pastor.
Yep, religious leader, that's what I was about to say.
Religious leader, yeah. In one of the parishioners. 16 is the age of consent, so a 16-year-old female can engage in sex with an adult man, but not if it's her youth pastor.
Right.
Right.
Or band director,
Right.
or teacher.
At that
things
point,
of that nature.
18 would be, or is there any, is there a limit in regards to age of consent?
Not in the
for that?
cases that I've seen, but I've also been outside of the prosecution of that. I think Sam's firm is handling a case similar to that. Do you know?
Yes, we actually have a couple. We just did one with a religious pastor. We've got one now with another religious pastor, but she's not a minor. But it's like electronic communication, and that's a whole nother story. But obviously 18, you do become an adult in the law. So I would say that, once you hit 18, it would be a lot harder to bring probably a charge against that. But I mean, there probably are still ways with the authority thing.
Of course,
the
there's always
statute.
to consider the mental capacity
Exactly.
of the individual involved. We see
That's
that
it.
quite a bit.
Yes.
Even if a person's 25 or 30 years old, but if
Yeah.
they're mentally incapacitated to
Right.
engage in a relationship or consent to sex, then
Yeah.
Well, I know some of those authority positions would be like correctional officers, for
Oh, yeah.
example, jailers.
Definitely.
Obviously teachers. Are there some others that I'm leaving out that, youth ministers, you mentioned that.
Right. Yeah.
One
Seems to
case,
be
it goes so
popular.
far as, but it goes so far as a booster for a school activity.
Oh, okay.
That fits the criteria. That's one of the cases we litigated, and it was actually on it wasn't a motion to dismiss, but a motion to amend the charge away from the aggravated offense because the person that was charged with the inappropriate conduct was not a teacher, not a band leader, but a band booster. And it was still found to be a position of authority,
Right.
which is a pretty tenuous connection to find, but
Right.
we got it done.
Right. And it's an automatic felony. If a person's convicted of that crime, it would be a felony.
Well, I think it actually depends on the level of the contact.
Right.
Oh,
It's
okay.
first degree, second degree,
Yeah.
third
Okay.
degree.
Intercourse, definitely. I believe if you were just a touch for sexual gratification
Right.
of a person's body, that'd be a Class A misdemeanor.
Right.
Okay. All right. Well, I think we'll have to wrap it up here. What I want to do is ask you all to, I guess for our audience, if someone wants more information about sex discrimination and sexual harassment, are there any resources that you would direct them to?
I would definitely say the EEOC's website,
Okay.
the statutes. If you just Google KRS 344, it comes up, or the website, I believe, is lrc.ky.gov. And it's Chapter 344. The Paducah Human Rights Commission, definitely. And then, of course, contact Sam. I'm sure he'd be also willing to help you.
Okay.
And one good thing, if you're wanting to learn about how to attack a situation like this, it's always good to learn about your enemy and what their plans are. So you might
Right.
want to Google, how employers avoid liability for sexual discrimination.
Oh, okay.
That's going to tell you what the alleged perpetrator is going to be not allowed to do or trying to avoid. And you can educate yourself that way.
Right. Anything else you all want to add to what we talked about? Let's touch for a minute, just for a second. I meant to ask this question earlier about the Pregnancy Act. Can you just in maybe 30 seconds or so, explain that and how that applies to the workplace?
Yeah, so basically women cannot, be discriminated against for having a child or taking, leave for the child. It cannot be, classified, well, I guess under the EEOC, it kind of is classified as a disability, a temporary disability for that woman. So she cannot be, if she returns to work, find out that she's, now been demoted to a different position.
Right.
So that's kind of what that does, and, it's covered by the EEOC with that.
All right. Well, I want to thank you all so much for being with us today.
Thank you.
That
Our
concludes
pleasure,
our
I'm sure.
session. I want to thank you all for joining us, and we'll see you again soon.